particular
Let's
one?
start with the summer rentals and move on.
Okay. Well, how to begin this? Our former definition of what constitutes a family, the zoning article 78, it led to numerous discrepancies. A lot of people were left confused about how to go about the process of obtaining a summer rental permit. The Daily Star printed about a list of, out of 900 property owners, there was actually 545 people that were listed as not having valid summer rental permits, as well as certificates of compliances. And I just look at that number and I think, well, clearly our legislation is confusing, misguiding, and needs to be changed.
And there's no IT department that's connected, to, I mean, it's so easy to organize that and email the landlords, and none of that's ever done.
Right.
So that we're informed and we know what we need to accomplish.
And even worse is if you were to call City Hall and ask, well, I'm a little confused about this, what should I do? You don't get any answers. It's simply you're left on your own, and after the fact you're in trouble.
I wouldn't say you don't. If you go down there, you can get answers. But the problem is, there's, like on a given property, you may have 7 different things. If you've got a number of properties to keep track of that and what the status is of it, they could very easily computerize that, and it would cut in half, I think.
Make it a lot more efficient, certainly.
Yeah.
Back to Article 78.
Sure.
So Article 78 caused a lot of stress for the community, especially the property owners. Now, after filing a Freedom of Information Law request, I searched for all court procedures and litigation that oversaw discrepancies with our zoning ordinances, specifically Article 78. And what I found was that since 2008 alone, in just a year and a half, the city has lost over $60,000 of the city's tax dollars in court litigation because property owners have had to sue the city in order to obtain the right to obtain this sort of permit.
They would have lost more if I had sued them.
Well, I'm thankful that you didn't, actually, on behalf of the city's residents. But what's even worse is going beyond what the city had to spend is what our actual members of this community had to spend. And when you look at that figure, it's actually well over $100,000. I've spoken with people such as Scafidi, Herkimer, and beyond, especially Martella. And Martella alone had to spend over $10,000 to address the situation, which, for anyone who's not aware, the former definition of what constitutes a functional family unit was overturned by Supreme Court Justice Kakoma. The fact that it had to go to the Supreme Court is ridiculous. In the case, one particular case, a family tried to obtain a summer rental permit, and their entire neighborhood complained and lobbied against it. There was a public hearing, and even at the public hearing, it was found that the family was abiding by all procedures that they were supposed to. However, regardless of that, they were still not given the permit that they should have, that they deserved. So they had to bring it to court. They only brought it to court after the fact that once they complained to the Common Council and to the Code Enforcement Office, the very next day there was a code officer on their front porch. The code officer did not have any identification. The code officer's only papers that they carried on them contained the names of the previous house owners. Therefore, they had no business addressing the current house owners. When this family called their lawyer and asked the code officer to leave, the next day there was a warrant out issued for their arrest, signed by Judge Bernier, stating that this family engaged in government obstruction. That was the charge. So the family is still actually fighting this as we speak. This issue was brought up on last March, and they've had to spend over $8,000 defending themselves, and now the entire issue was brought to appellate court, the state's highest court, all to obtain a summer rental permit that they should have gotten anyway.
It's a little nuts, yeah.
Exactly.
That's all nuts. Well, my concern is, I lobbied very strongly to have objective rules. I didn't mind having one parking space, or having
compromising with the city.
Yeah, right. Or having a certain amount of density in the neighborhood, or whatever. If it was 200 feet, to the next one.
Sure.
But they left in provisions within that law to make it non-objective, so that you really...
Exactly.
And I got the short end of the stick of that. So would you make an initiative to change that law?
Well, I already have. When there was a public hearing for the new definition of what constitutes a functional family unit, I was the only candidate to be at the public hearing and actually express that the new definition continues to carry unlawful provisions within it. It targets and singles out gay men and women. It singles out the elderly. It singles out the disabled. And there's a lot of room for people to continue to sue the city, thus losing even more of our precious money. The proposal that I addressed to the Common Council and to Mayor John Nader is what I call a trilateral agreement. What it is it's an agreement between the city's officials, the police, and both schools, working together in an effort to provide substance for the community, provide peace and prosperity for the community, but also, most importantly to me, putting blame on where blame is due. Right now, the current definition and the former definition puts the burden of social behavior completely on the property owner.
This is true.
And if I'm renting from you...
Unfairly, totally unfairly.
Exactly. If I'm renting from you and I choose to disturb my neighbors in the middle of the night, well, then I should be reprimanded.
Exactly.
Why should you?
I had a mentally challenged tenant who left garbage in the backyard, and I had invested in fortune renovating this property, and then I wasn't given a summer permit. What did that behavior of that tenant have to do with me?
Exactly.
Nothing.
Exactly.
So, and I think it was politics, but that's another story.
Sure.
So,
sure. So going back into the proposal.
Totally agree. Yeah.
Going back into the proposal, basically what it said, it allows property owners the right to put inside of their contracts with those that they're renting out, the fact that if you are found to be guilty of being a public disturbance on 2 occasions, it's a 2-strike rule,
Right.
well then you have the ability to kick them out immediately. That's right. That's fair. That's fair on all parties. You should know that it's your responsibility to behave accordingly with your community and be respectful with your community. But you should also know that you're being protected. To me, property owners are entrepreneurs, and if we are not promoting people's ability to receive money, to obtain money, to provide for their families, then we're not doing our jobs correctly. My proposal does just that. It ensures that you're safe. It ensures that the neighbors who are complaining about the noise ordinances are getting their needs addressed.
Right.
But it also takes the blame off of the city itself and puts some more responsibility on the schools.
That makes sense. Actually, we could put that in our leases, that if they're, if a tenant has violated the local noise ordinances more than once,
Right.
we have the right to break the lease.
What's exciting about my proposal, and I just want to go into this, is the fact that my proposal, I was approached about a month ago from the National Apartment Association. Now they've been around for 70 years. They're an established firm that preserves renters' rights. Okay. They approached me because they are dealing with a very similar situation right now in Virginia, and they had found in the Common Council's minutes my proposal. They asked me about it. They asked me to go in depth about the situation as I am now, and they asked for a copy of my proposal, which I gladly gave them. Right. What's interesting is that my proposal has now actually been adopted and is being used as a guidance for how other communities across the country should propose future legislation describing zoning ordinances. The fact that my proposal is being recognized across the nation now, I think clearly demonstrates that it's credible, it's fair, and it's the right way to push forward as a community. Just because John Nader and our Common Council refuses to acknowledge lawful legislation does not mean that it always has to be that way. As mayor, I believe I have the correct insight to understand that yes, we need to protect our rights, our communities, members' rights, and right to peace and quiet in the middle of the night. But we cannot just promote unlawful legislation to dictate certain results.
Yeah. Well, I have my peeves because I was the most proactive of the landlords.